Ladies and gentlemen, hello. My name is Paul Cheng, and I wanted to thank you for coming to my channel. I wanted to thank you for joining me. Today, we're going to be talking about and going through more of the information regarding hire to fire, both from the employer side and the employee side, so you know your rights and obligations in California. When you hire an employee, one of the important laws that people need to understand, there's not too many documents that need to be done when you hire an employee. But one thing that I want to cite to you, I have the law in front of me, is the California Wage Theft Act. California Wage Theft Act. And the California Wage Theft Act requires that you give specific information to your employee at the inception of the relationship, or it is illegal. I'm just going to go over them really fast. The first one is the rate of pay. How are you paying them? Are you paying them hourly? Are you paying them salary? These are all very important. And when you pay your employees, you also have to provide that information. Is it once a week? Is it twice a month? Is it once a month? Just let you know, if you are exempt, you can get paid once a month. But if you're a non-exempt, minimum is twice a month. Second one is if you're providing any allowances. What that means is if you're having any deduction on a meal credit, living credit, things of that nature. A lot of times you have apartment owners. They actually have a credit or allowance that they factor in when they're paying their employees because maybe they get a free apartment and they get free meals. What is your regular payday? Earlier I talked about it, but you actually have to tell your employees when your payday is. You actually have to tell your employees what is the name of the employer. Your legal name of the employer and your DBA are both required. You have to do it, California law. The physical address of the employer's main office or principal place of business. You have to give it to your employee at the time that you hire them. The telephone number of the employee, it seems obvious, you still need to do it. You have to provide your workers' compensation information to your employee. That's very critical. And really, the labor commissioner updates it, so any new information that the labor commissioner needs to provide. A lot of employers ask me, do I need an employee handbook? Is that required in California? It's required where I'm from, particularly in Asian countries. An employee handbook is absolutely a requirement. California does not require an employee handbook. However, a sexual harassment policy, for example, there are certain policies that are required that are given to the employee. Now, in California, it's very easy, just let you know, every employee that comes in, they need to take a 1 hour or 2 hour sexual harassment training class that is mandatory and required. The state of California provides that information to you for free. It's a video. If you're a manager, it's 2 hours. If you're a regular employee, it's 1 hour. Please do it, it's free. The Wage Theft Act, just lets you know, if you type in California Wage Theft Act, they have the form that's ready for you. Typically, many companies provide an offer letter that has all the information, but if you fill out the form, California Wage Theft Act form, it is everything that needs to be done for your employees. Getting back over to the handbook. If you do have an employee handbook, I want to warn you about your employee handbook. California employee handbooks cannot reduce the bare minimum requirements in California, but they can increase the benefits and the requirements. So I'll give you an example. If your employee handbook says our minimum wage is $25 an hour and you are sued, you cannot say we pay California minimum wage. We did not violate the law. You are subject to the $25 minimum wage because your employee handbook said it. So employee handbooks could give more, they cannot take away from California law. Big worry about that. A lot of employers and employees say to me, what is an employer required to do when I file a complaint? When I file a complaint with an employer, what is the employer obligated to do? I always say this, an employer is not allowed to retaliate, discriminate, harass you based upon your complaint. They're not able to say, oh, you think you're allowed to get paid overtime after 5 hours? Overtime is supposed to be paid on Christmas Day. I'm fire you. That's illegal in the state of California. They can't do that. Because in California, an employee can be able to make a wrongful but good faith complaint. I'm going to say that again. An employee can be able to make a wrongful but good faith complaint. So if the employee comes and says, hey, every time there's a holiday, Christmas, New Year's, Juneteenth, etc., you're supposed to give me pay, or you're supposed to give me overtime. You can't be retaliated against that. And in fact, in California, it says that if an adverse action goes against you, for example, within 30 days of you making a complaint, it's presumed that you've been retaliated against. If you've been retaliated against within 60 days of you making a complaint, that's presumed retaliation. Presumed. So the employer actually has to justify why you've been terminated, why you've been retaliated against. It's very, very big in California. So the first issue is employer can't retaliate against you. Can't make an adverse decision against you just because you make a complaint that may not be true, but it's held in good faith. The second issue that an employer must be able to do for most of the complaints is to do really what's called, I'm going to use it loosely, interactive process. They need to be able to work with you to be able to figure things out, right? So if an employee comes and they say, hey, I've been sexually harassed, an employer can't be able to say, okay, so what? Can't do that. They have to do, I'm going to use it loosely, interactive process to be able to work with you to be able to find a resolution to your specific issue. If the employer doesn't, and I'm using it loosely because the interactive process actually has some legal ramifications to it, but if the employer really isn't working with you, then the employer can be found to be liable even when you're wrong about the discrimination, even when you're wrong about the sexual harassment. In California, it's very interesting. The employer needs to engage with you. When they don't engage with you and work with you in a reasonable manner, then they can be found liable even when the underlying claim is found untrue. Another issue that I get is, well, how much does the employer need to do? What is this interactive process that's being talked about? I always say this. The law doesn't require perfection. It just requires the employer to act reasonably in doing so. And so at minimum, it needs to be in writing. While that's not a California requirement, but I think most jurors believe that when it's not in writing, the employer really didn't do it. Now, many employers say, well, do I need to involve the employee? Is that a requirement to involve the employee? And the answer is, it's not a requirement to involve the employee. But again, most jurors in California are going to be employees. And so therefore, you should involve the employee. That's really part of best practices, to inform the employee what your plan of action is and to see if the employee is willing to interact with you to be able to say whether they're satisfied about this interactive process. Because look, let's just give you an example. Let's pretend an employee comes and they say, I've been sexually harassed. And you say, oh my God, you've been sexually harassed. Talk to me about it. I intend to hire somebody else to be able to come in and do an investigation. Employee says, no, I will not tell you. I've been sexually harassed, but I'm not going to tell you who it is. Well, it's very difficult to do a sexual harassment investigation if your employer refuses to cooperate with you. And in that sense, I believe that the employer has done their best. Now, from the employee side, I want to say there are many cases that I see that come into our office. The employee refuses to cooperate with the employer. They say, no, I'm not going to tell you. I don't like you. You're mean. You're judgmental. That's a bad move. It really is. It makes your case very weak when the employee makes a claim but refuses to cooperate. There's actually many cases where judges have ruled against employees because a failure of cooperation really shows that the employee does not have a good case. So I want to warn you about that. Thanks for joining me. We've been talking about a lot of issues related to employer, employee, and labor law. Next time, we're going to go further on those issues to be able to discuss more detailed information and what I call hire to fire. Thank you.